Hello, class. So, we will be beginning with liberalization and globalization of legal profession. Liberalization means liberal. The word refers to freedom or something getting free or to remove the restrictions, right? And globalization means that it is spread throughout the globe. The era of globalization called for removal of barriers in trade and services to liberalize economies. That means to remove the restrictions in trade, and here we are talking about the profession as the service provider. And what is the service that is provided over here? The legal help or advice or to fight a particular case and render justice to the respective client. Right, this is the service which they are providing, and a proportion of money is taken as fees. So, the globalization, you know that the world is in the era of globalization where everything is so easy to access, and you can have the connection of throughout the world. You can trade globally at the click of a button through internet, right? So it was important in this era that the economies can be free of certain restrictions. 1990s, for the first time, RBI granted permission to 3 law firms to establish their license offices in India. In 1995, General Agreement on Trade in Services under WTO came into force. Under GATS, a credible and reliable system for liberalizing legal services was created that applies to liberalizing the legal profession and corporate legal services. So that means under the General Agreement on Trade in Services, under the organization of WTO, which is for regulating the trade in the world, a credible and reliable system was created so that the legal services can also be free of certain restrictions, and regarding the legal practice as a whole, and also the legal services which are provided in the corporate sector. Nowadays, in every company, in banks, or in every sort of enterprise or institution that you interact with, you may see a legal services or a legal advisor post is designated, and a person is appointed, or each company also have its legal team for that matter, right? So that is what we call corporate legal services which are provided for the companies in the corporate sector. Legal advisory, legal documentation services, legal certification services, information services, etc. were liberalized. BCI has constantly passed several resolutions between 2002-2007 opposing the opening up of Indian legal profession to foreign lawyers or foreign law firms. That means for practicing in India now, foreign lawyers are also they are, see, liberalization means whatever restrictions are being put, they are removed. So there was a restriction earlier, like we have evolved from the British system to independent era. So under Britishers, the lawyers, the applicable laws, the judges, all were English people, right? And it was realized that there is a ruckus, or there is a problem, because the English laws which were being implemented on Indian citizens, they were not rendering proper access to justice, and it was not also administered efficiently among the citizens, because that was English laws applicable on the circumstances of another country which were not suitable for India. That's why over time it was decided by the British government that some laws of like personal laws should be applicable according to the religion to which the person belongs. Then they also appointed some experts of certain religions who could interpret and give advice on a particular religious matter or custom or tradition to the judge, and on the basis of that advice the judge would render the opinion, but judges were still English, right? So we have gone through all that. After that, there was a Advocates Act, under which it was decided that okay, now Indian practitioners or any other nationality or religious person can be entered as a lawyer into the profession. But it was only in the independence era that it was decided that it will be only Indians. Now globalization or liberalization in this sense would mean that we are opening the market for everybody regardless of who the person is. Now you see that or suppose an American lawyer who may not have thorough knowledge of the Indian laws, he may not have studied Indian laws, because of course if he has graduated from America, any of the states of America, he has the knowledge of that law of the land. In every country law of the land is being learned, right? So वहाँ के लॉ ऑफ लैंड के हिसाब से उसने अमेरिकन लॉज पढ़े हैं, उसने इंडियन लॉज नहीं पढ़े हैं, या अगर पढ़े भी हैं तब भी ऑन practical aspects, or he would not be having a thorough understanding because he is not practicing those laws. He is not brought up in connection or interaction with those laws, right? So he will not be able to understand the problem or predicament of the person. Like, I'm no offense or no comments on the credibility of any person as a lawyer or any profession, but just imagine an American or an Indian who would be better fighting the case of an Indian citizen, right? And if you may have seen the qualifications which are there for an advocate or for doing LLM or something in certain colleges for being judges, what are the qualifications? The first one is he or she should be the citizen of India. So these are the basic and the foremost restriction which is put as the qualification. Liberalizing that would mean removing such restrictions. Fine. So, and globalization means that you would be opening it for the whole world. I hope these two terms, how it would be applicable, that is clear. That's why BCI has opposed that it should not be open to foreign lawyers or foreign firms. It should not be open. And BCI is the only regulating authority regarding legal profession in India. 2011 judgment delivered by Bombay High Court on a PIL filed by a non-profit organization, Lawyers Collective, was held that foreign law firms could not be permitted to set up offices in India. However, Madras High Court, in response to a PIL filed by A.K. Balaji, permitted foreign lawyers to give advice to Indian clients in India on a fly-in and fly-out mode. That you will come inside, give advice, and then you will fly out. You will not be allowed to practice. You can give advice, but practicing it or becoming a lawyer here, that would not be allowed. So that is giving advice. Globalization of legal profession. Globalization in its literal sense means dictionary meaning, connotes the integration of economy and legal structure of a nation with the world order. So economy, how it would be integrated with the world order when the market is open to trade from across the globe, right? Any country can sell its product to India or services to India, and we can also interact with it. That is how the economy will get a boost. Legal structure is that laws or legal firms would be allowed. Globalization of law refers to a utopian condition. Utopian means something which is too ideal to be true. इतना ज़्यादा perfect या ideal चीज़ है कि वो सच हो ही नहीं सकती. ये वाला ideal, ठीक है? In which the whole world live under a single set of legal rules which are imposed by an international body. You know, there are several international bodies, right? WTO is one such, which we have read just few minutes before, right? But why we say that international law is a weak law? Because it is not binding as such. If a country does not obey their law, it will not be prosecuted or punished or sentenced or be fined against or any such thing, right? But the local laws of a country, means which are applicable in that particular jurisdiction, they are strongly binding, and if a person has violated that, he will be sentenced or prosecuted or punished for that matter, or he may also be subjected to a fine of certain amount as it is decided by the court, right? We have studied that in class 11th also. So it is difficult being the present situation that every country is a sovereign. It has its own jurisdiction to regulate upon, to make policies, laws, and to govern the citizens, right? Every country is a sovereign, and it is not bound to obey or to be bound by the external influences or advices that are pouring inside, right? It has its own wish how to handle its country. Yes, India is also a sovereign country. So it is very utopian that, and every country's political, social, economic status is also different. The level of development of each country is different. That's why we have divided the world into three: developed, developing, and underdeveloping countries, right? So it is difficult, or it is, as it is said, a utopian condition that the whole world will be under a single set of rules that will be equally applicable to all. ऐसा रूल बन ही नहीं सकता. इंडिया में ही अगर आप देखें तो हर एक स्टेट गवर्नमेंट की अथॉरिटी है कुछ मैटर्स पे रूल बनाने की. दैट इज़ द स्टेट लिस्ट ऑफ द इंडियन कॉन्स्टिट्यूशन, राइट? सो क्यों हमने ये अथॉरिटी दी? क्योंकि वहाँ पर भी हर स्टेट का पोजीशन, उसका सोशल स्टेटस, लोगों का जो वहाँ रह रहे हैं उनका क्लाइमेटिक पॉलिटिकल कंडीशंस अलग है. एंड द लॉज आर मेड टू adhere to or to regulate the conditions and to solve the problems which the people are facing, right? और उनको जस्टिस देने के लिए या उनकी प्रॉब्लम्स को सॉल्व करने के लिए, ख़त्म करने के लिए रूल्स बनाए जा रहे हैं ताकि जो भी प्रेडिकामेंट है उसको हम हटा सकें, राइट? सो इट इज़ वेरी डिफ़िकल्ट कि हम एक कंट्री में जहाँ डिफरेंट बॉडीज़ है रूल्स बनाने के लिए, डिफरेंट चीज़ों के लिए अलग रूल बना रहे हैं, डिफरेंट लोगों के अलग नीड्स हैं, तो हम कैसे सारे वर्ल्ड को एक सिंगल सेट ऑफ रूल्स में रेगुलेट करवा सकते हैं, राइट? एंड देयर आर टू रीजंस ऑल्सो. एज आई टोल्ड यू, इंटरनेशनल लॉ इज सेड टू बी अ वीक लॉ, एंड ऑल्सो दैट every country is sovereign in its self. That is also one of the reason why international law is a weak law, क्योंकि वो इम्प्लीमेंट ही नहीं कर पाता. जहाँ वो इम्प्लीमेंट करने की कोशिश करता है, कंट्री मेंटेन्स इट्स सोवरेनिटी एंड इट इज़ नॉट बाउंड टू ओबे इट. Adopted by global consensus or parallel development in all parts of the globe. That means either all the worlds they come to an agreement. Consensus means they agree that okay, we all will be adhering to this law, और हमने साथ में मिलकर ये law बनाया है और हम सब इस set of rules and regulations से agree करते हैं. That is consensus. और parallel development in all parts of globe. That means कि पैरेलली उस सेट को एनफोर्स करवाने के लिए पैरेलली हर कंट्री में वो रूल्स को इम्प्लीमेंट करा गया या उसके लिए डेवलपमेंट्स किए गए कि ठीक है, नाउ वी आर एनफोर्सिंग इट एंड इन दैट डायरेक्शन वी हैव टू मूव अहेड. In today's world of increasing international trade and interdependence, why interdependence? Because any country is not self-sufficient in its own. Import and export is conducted by each and every country of the world. हम किसी से कुछ सामान ले रहे हैं, सॉरी, तो अदर कंट्री इज़ ऑल्सो परचेसिंग सम गुड्स और सर्विसेज फ्रॉम अस, राइट? ऐसा ये ट्रेड एंड कॉमर्स हो रहा है, एवर एंडिंग. दैट्स वाई आज के टाइम पे हम कहते हैं कि बहुत ज़्यादा इंटरकनेक्टेड और ग्लोबलाइजेशन हो गया है, क्योंकि मार्केट बहुत ज़्यादा ईजिली थ्रोन अप है टू द वर्ल्ड, राइट? सो द नीड फॉर ट्रांसनेशनल लॉ हैज़ इंक्रीज्ड. ट्रांसनेशनल मीन्स विच इज़ अमंग द कंट्रीज़, क्योंकि बहुत ज़्यादा इंटरडिपेंडेंस है, इंटरनेशनल ट्रेड भी बढ़ रहा है, तो ज़रूरत है कि अमंग कंट्रीज़ भी कोई लॉ होना चाहिए. इफ़ we are, see, if for the business of two individuals in India, we have Indian Contract Act, right? We have Sales of Goods Act or Transfer of Property Act, right? And India is a small country if we compare it to the number of countries in the whole world. उस हिसाब से तो सिर्फ ये एक कंट्री की बात है, India is not a small country, otherwise it is a very big country with a lot of diversities. But if I talk about in reference to the whole world, which has to handle the inter border trade of so many nations, सो अगर हम एक कंट्री में जो भी इंटरेक्शंस और ट्रांजैक्शंस हो रहे हैं उसको डील करने के लिए हमारे पास कंज्यूमर डिस्प्यूट्स एक्ट है, राइट, कंज्यूमर रिड्रेसल ट्रिब्यूनल्स हैं, येस, ऑल्सो वी हैव डिफरेंट कोड्स ऑफ लॉ, इंडियन कॉन्ट्रैक्ट एक्ट है. आप कुछ भी सामान, बेसिक सामान जो आप किसी शॉप पे जाकर ख़रीद रहे हो, यू हैव टू टेक अ बिल ऑफ दैट, राइट, एज अ प्रूफ इन फ्यूचर कि कोई भी डिस्प्यूट रेजोल्यूशन करने के लिए वो एविडेंस काम आएगा, राइट. वरना बंदा मुकर सकता है कि मैंने इसको सामान नहीं बेचा, ये सामान मेरी दुकान से नहीं लिया गया, बिकॉज देर इज़ नॉट वन शॉप विच सेल क्लॉथ्स, राइट. फॉर एग्जाम्पल, देर आर न्यूमरस शॉप्स in a particular city or in a particular market of that city which can sell the same variety of clothes, right. So उस चीज़ को prevent करने के लिए as an evidence it can be used in future. Yes, similarly that is a very small transaction or business that I have given you the example of. Now अगर हम country wise import and export की बात करें तो huge quantities टन्स में बिज़नेस या इम्पोर्ट एंड एक्सपोर्ट होता है. उसको रेगुलेट करने के लिए अगर हम किसी कंट्री में लोगों के ट्रांजैक्शन को रेगुलेट करने के लिए लॉ बना रहे हैं, राइट, ताकि इन फ्यूचर अगर डिस्प्यूट आए तो इस लॉ से वो चीज़ें गवर्न होंगी कि कैसे क्या करना है, हाउ द कोर्ट हैज़ टू प्रोसीड, क्या अगर किसी ने कॉन्ट्रैक्ट ब्रीच किया है तो उसके रेमेडीज़ क्या होंगे, राइट, कॉन्ट्रैक्ट क्या होता है, ये सारी चीज़ें डिफाइंड है इंडियन कॉन्ट्रैक्ट एक्ट में, राइट. और किस चीज़ को ब्रीच माना जाएगा कि उसने सामान उठा लिया लेकिन पैसे नहीं दिए, दैट इज़ अ ब्रीच. सेलर के साथ गलत हुआ तो सेलर की क्या रेमेडीज़ हैं, राइट. ये सारी चीज़ें वहाँ पर है. कोर्ट को कैसे प्रोसीड करना है, क्या प्रोसीजर फॉलो करना है, रेमेडी में कि वो क्या क्या प्रोवाइड कर सकता है, कॉम्पनसेशन, डैमेजेस के क्या, राइट. सो ऑल दीज थिंग्स आर रेगुलेटेड बाय इंडियन कॉन्ट्रैक्ट एक्ट विच इज़ टू प्रोवाइड लॉज फॉर regulating transactions for the citizens of a particular country. तो यहाँ पर तो ट्रांसनेशनल हो रहा है और क्वांटिटी भी बहुत ज़्यादा होगी, लैक्स ऑफ टन्स, थाउजेंड्स ऑफ टन्स. तो उसको रेगुलेट करने के लिए भी अमंग द कंट्रीज़ कुछ लॉ होना चाहिए ना. दैट इज़ द मेन पर्पस ऑफ व्हाट इज़ रिटन ओवर हेयर. और इसके लिए मैंने इंडिया के रेफरेंस में एग्जाम्पल लेकर आपको बताने का ट्राई किया है. आई होप द थिंग्स आर क्लियर. More and more countries open their economy partially or completely. There is a growing need to recognize and work towards a uniform system of law, but it is difficult. As globalization increases the flow of people and information across borders, there are increasing opportunities for trained lawyers. Typically, the opportunities are available in common law based jurisdictions such as US, UK, and Australia and Canada. So why common law based jurisdictions? Because common law, right, torts, if you have heard of, or we have did it also, right, torts, it is based on common law. तो ऐसे jurisdictions में या ऐसे legislations में scope है, right, of practicing inter borders, because that somewhere or the other is common to every country, like US, UK. Unlike many other professions, lawyers trained and licensed in one jurisdiction may not be licensed to practice in other jurisdictions. As I told you, that an American lawyer would not be well versed with the Indian laws, right? उसको नहीं पता होगा कि इंडियन कॉन्ट्रैक्ट एक्ट क्या है, उसको कैसे इम्प्लीमेंट करवाना है, कैसे उसके बेसिस पे फाइट करना है इन एन इंडियन कोर्ट, क्योंकि वो लॉ उसके यूएस में तो लगेगा नहीं, तो वो क्यों पढ़ेगा उसको, right? And lawyers trained in other jurisdictions will have to re-qualify in order to practice in the foreign jurisdiction. ठीक है, आप अमेरिकन के लिए क्वालिफाइड थे, बट आप अगर इंडिया में क्वालिफाई करना चाहते हो, इफ़ यू वांट टू बी अ क्वालिफाइड लॉयर और टू बी वन हु कैन फाइट द केस फॉर इंडियन इन एन इंडियन कोर्ट, तो आपको यहाँ के क्वालिफिकेशंस फुलफिल करने होंगे. For being a lawyer in India, the qualifications which you have fulfilled for any other country, that will not work, right? A simple reason is that different countries have different legal systems and laws are framed according to social, political, civil conditions of that country. यही तो मैं इतनी देर से बोल रही हूँ, right? Women and legal profession. Indian women were granted the right. Now see, why it is a separate topic, because as you know, women have always been the disadvantaged or vulnerable section of the society. They were and they are not today even treated as equally as men, right? We say that it is equality, but it is not. The fact that various women centered laws are still in force in India is evident that there is gender inequality still existence in India. So men, see, Indians को ही right to practice after independence मिला था, या बहुत ब्रिटिश रूल में लास्ट के ईयर्स में मिला था. सो मेन को ही इतना लेट से मिला, तो इंडियन वुमेन उनके और थोड़े टाइम बाद आई. इंडियन वुमेन के लिए प्रोफेशन की लाइन मेन के हिसाब से, इंडियन वुमेन वर नॉट अलाउड टू स्टेप आउटसाइड ऑफ द हाउस. देयर वॉज अ जेंडर रोल विच वॉज स्पेसिफाइड फॉर देम, राइट, which is to stay at home, do household chores, take care of the husband's family or children. All such things were only typecasted for women to do. तो उनके लिए किसी प्रोफेशन में पार्टिसिपेट करना बहुत टाइम बाद शुरू हुआ. एंड नाउ फॉर दैट मैटर वी विल बी टॉकिंग अबाउट दैट व्हेन एंड हाउ women stepped into the legal profession. They were granted the right to take up legal profession and practice as advocates in the courts of law after passing of Legal Practitioners Women Act of 1923, abolishing the bar on women from practicing law. So there was a bar tha, which was removed by this act. This right did not come easily to women in British India. As I told you, that was British India. 1916 Calcutta High Court, 1922 Patna High Court held that women otherwise qualified were not entitled to be enrolled as vakil or pleader. Patna High Court case, Miss Hazra, the petitioner, secured a BL degree from Calcutta University. She was refused enrollment. She challenged this in the High Court of Patna. Court ruled that sections of Legal Practitioners Act referred to males and not females. 1793, no women had ever been admitted to the role of pleaders. Role of pleaders means the register in which the pleaders have been mentioned. Allahabad High Court took the lead by enrolling Miss Cornelia Sorabji as first Indian lady Vakil of Allahabad High Court on 24th August 1921. By a decision of English Committee of Court, as Administrative Committee was then called, consisting of Chief Justice Sir Grimwood Mears. So English judges थे, तो उनके कंसल्टेशन पर या उनके डिसीजन से ही किसी इंडियन वुमेन को अपॉइंट किया गया था. पटना हाई कोर्ट हैज़ रिफ्यूज्ड टू एनरोल वन, बट इलाहाबाद हाई कोर्ट में फर्स्ट लेडी वकील आई हु वॉज Cornelia Sorabji. Legal Practitioners Women Act, women finally were able to practice as lawyers in India. So you have to remember by virtue of which legislation women were allowed to practice in India and to enter into the profession. Also the year of it, which is very basic, and the first lady Vakil of India, and in which High Court. Okay. Since then, the number of women entering has increased. Gender bias still prevails, as I have told you. According to a data tabled by the Law Ministry in 2022, 15.3% of lawyers are women. However, recent studies indicate that gender-based disadvantages are gradually being eliminated, especially in the corporate law sector. I have told you what is the meaning of corporate sector. It is gradually being eliminated. That means it is in the process of being eliminated. It has not fully done yet. Okay. Now, legal education, which is regulated by BCI. BCI prescribes minimum standards of imparting legal education in India. That what would be the basic requirements? Like education is provided by educational institutions, For that matter, degrees are provided by colleges or universities, right? So what should the universities have as the basic criteria or the basic standards for being eligible to allow to impart the legal education? Preceding the liberalization in 1980, BCI, UGC, Law Commission and various state governments have led to establishment of various law schools in India. This revolution was pioneered by Professor N.R. Madhav Menon, who was instrumental in setting up of the first law school, that is National Law School, Bangalore. And present we have 24 in India. NLUs we are talking about. Okay, so National Law Schools, those are NLUs. You may have heard about them. The first one is NLSIU Bangalore. Okay, it is the topmost and the oldest law school because it is the first one to get established, so it is the oldest at present and the top rated one. पूरे कंट्री में जितने भी लॉ स्कूल्स हैं, of all the central universities, colleges combined, even private ones, number one is this, top ranking. So here you have to remember that who has pioneered, which was the oldest one to get established, how many are there in present. These are some factual information that is important. 2 ways to obtain a degree: to practice law and enroll with BCI. For that matter, Bar Council can be of the state in which the person is domiciled or any state in which the person wants to get enrolled, and also it can be BCI. Also there is a bar association. For that we have a separate exam called All India Bar Examination, which you have to pass if you go on to practice. So if you get registered on a particular date, you have to pass this examination within 2 years of this date of registration, and this registration is called provisional registration or enrollment. It is not permanent. If you want to get permanent, then you have to pass this examination, and that would be your permanent enrollment as an advocate in India. Fine. So what are the 2 ways? Degrees you have to obtain. Degree can be a 3-year LLB program, that is an undergraduate which requires a prior undergraduate degree, because this is not a degree in itself. LLB is not a degree in itself, it is a program. Okay, for that you have to get a prior degree. चाहे आप इसके पहले BA करो, या आप इसके पहले BSc करो, या BCom करो, या BBA करो, या BA करो, कुछ भी करो, जितनी भी डिग्रीज होती हैं इन वेरियस फील्ड्स, उसके बाद अगर आप LLB करोगे तब आपको लॉयर माना जाएगा. सिर्फ LLB करने से इट इज़ नॉट क्वालिफाइड. दैट्स वाई इट इज़ रिटन प्रायर अंडर ग्रेजुएटेड डिग्री. ठीक है. एंड 5 year इंटीग्रेटेड. वाई दिस? बिकॉज सी देखो यहाँ पे भी है ना, BA, BBA, BSc, ये सब. सो दिस BA, BSc, BBA, दिस फुलफिल्स द क्राइटेरिया ऑफ दिस थिंग. दैट्स वाई इट इज़ प्रोवाइडेड इन इंटीग्रेटेड. और इस इंटीग्रेटेड का फ़ायदा क्या होता है? इन द सेंस कि 1 साल कम हो जाता है. तो अगर आप ऐसे अलग अलग डिग्री करोगे, लाइक BA के 3 साल या BSc के भी 3 साल की होती है BSc, उसके बाद LLB तो 3 साल की है ही. सो दिस इज़ 3 + 3 6 years you have to study. But for the integrated ones it is a 5 year course. So वो 1 साल बेनिफिट हो जाता है, बाकी कोर्स ऑलमोस्ट उतना ही होगा. Which commences immediately after secondary school. That means after you have passed your class 12th, you can get enrolled in such degrees. Some universities offer both 5 and 3 year programs. BCI recognizes universities whose degree in law shall be a qualification for enrollment as an advocate. That means universities को उसने qualify किया हुआ है कि this university and the course of law which it is providing, that is certified. ठीक है, मतलब अगर आपने इस यूनिवर्सिटी से लॉ की डिग्री ली है तो you are qualified to be enrolled as an advocate, or you are qualified to sit in future competitive examinations that are being conducted. That's why if you go through the qualifications or the eligibility criteria of any examination, उसमें लिखा होता है law degree from any university certified by BCI. ठीक है, so that certification is important. It visits, inspects universities or directs state bar councils to visit for this purpose. कि आप देखो कौन सी डिग्री प्रोवाइड कर रहे हैं, कैसे एजुकेशन इम्पार्ट कर रहे हैं, इज़ इट एलिजिबल इनफ, क्या वो मतलब इस लायक है उनकी एजुकेशन इम्पार्ट करने का तरीका या जो सब्जेक्ट्स उन्होंने रखे हैं अपने प्रोग्राम में, करिकुलम में, इज़ इट वेल इनफ कि हम इनको सर्टिफाई करें. ठीक है. ऑल्सो इट रिलीजेज अ लिस्ट ऑफ फॉरेन डिग्रीज दैट इट रिकग्नाइजेस. कि फ़ॉरेन में जैसे कुछ लोग होते हैं LLB यहाँ से करने के बाद LLM फ़ॉरेन से करके आते हैं, बट स्टिल दे कैन प्रैक्टिस. सो दैट इज़ बिकॉज वो लिस्ट ऑफ फॉरेन डिग्रीज में वो पढ़ता होगा उनका LLM. ठीक है. There are around 1721 law schools in India. Reformation of legal education undertaken since late 1980s at initiative of BCI, UGC and various state governments has led to establishment of various national law schools. This we have done. Its establishment marked beginning of reform of legal education. There are now 24 national law schools and 22 of them have a common entrance test, that is CLAT. NLU Delhi, it is a separate ALET, and number of other law schools, that is law school admission test. ठीक है. and some have their own separate entrance test. so that is the autonomy of the institutions कि क्या वो CLAT के साथ मर्ज होंगे या कॉमन जो यूनिवर्सिटी टेस्ट आजकल होता है CUET उससे मर्ज होंगे या अपना सेपरेट ही करवाएंगे. so that is the autonomy. Then from USA we will be taking up in the next video. Thank you so much.